Okay. Share my screen. Oh, I want to share this in a different way. Do, 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 do. There we go. Okay. Okay. Continuing through the purchase agreement, we stopped at the predatory offender notice. So just a reminder, we can't tell anybody if there's predatory offenders in the area. They have to go to the website to be able to do that. Okay. We have no duty to disclose other than telling them there's a website and they should go there. Then we get into the disclosures. Okay. What we're telling the buyer here, what the contract is telling the buyer here is they have a right to walk through property prior to closing, right? This is the final walkthrough that we talk about right before closing, and to make sure that the property is in substantially the same condition as of the date of the purchase agreement. And when it says the date of the purchase agreement, they don't mean the final acceptance date. They mean the date that you wrote this purchase agreement, right? This top date right here, which we fill in. Okay. If you get all the way to closing and the property is not in substantially the same condition, you essentially enter back into negotiations. Per the contract, the seller has to put the property back into the condition it was in. However, most of the time, the buyer wants to move in and move on, and they don't want to worry about the seller having to fix a hole in the wall that happened when they were moving out furniture. So most of the time, what happens is some kind of monetary value is negotiated right before closing. This is also why it's important to do the walkthrough with your buyer before closing happens. Okay. This goes on to say that the buyer has received one of the following, either the disclosure statement or the alternatives. If you have not received either because the listing agent hasn't put this online yet or hasn't sent them to you yet, then you need to make your offer contingent on your buyers reviewing, and approving the seller disclosures. And you would put that in the other category down here. Okay. Um, so you wouldn't check anything and you would put a clause in there. Um, then it talks about the description of the property condition. Please remember that the disclosures, when the seller puts no, when they answer no on the disclosures, it does not mean that that doesn't exist. It just means that the seller's not aware of that existing. For instance, if there's mold, if the seller's not aware that there's mold, they would answer no on the disclosures. That doesn't guarantee that there is no mold in the house whatsoever. That's not what that guarantees. It just says the seller's not aware of any.
Yep.
Could be in the walls, in the roof, right? Somewhere in the basement. So they might not know. So please don't forget to let your buyers that. Then it talks about buyers received any inspection reports by the municipality towards the cities. There is inspection reports that have to be done. Point of sale inspections is what they're called in some counties towards the cities. We don't have any up north of St. Cloud, so you don't have to worry about that. Okay. Well, unless you're selling in the cities. Terry, do you know about Fargo? Or West Fargo, is there any point of sale inspections required?
No, it seems like up here we get a lot of move out clean type situations in
Mm,
the purchase agreements where they make a note that it needs to be move in ready and it has to be done by a professional cleaning service and it can hold everything up. But that's
okay.
usually what we get here. But um, I was going to say there was one caveat
Mhm.
on the walkthrough. I wouldn't do it the day of closing. I would always schedule that a day ahead of time so that you
Mhm.
have time to come back and renegotiate things if there are things that are out of place. And also make sure that the lender sends you uh, the closing statement so that you can make sure everything is right on it as well. But
Mhm.
that's not on this part of the purchase agreement. The other thing I was going
Yeah.
to mention was that, so in Alexandria, one of the
Mhm.
properties we were looking at, it didn't have city water uh, into the home, but it had it at the street.
Mhm.
However, the house before this house was in the city limits, and this one was not in the city limits. So when you start talking about city water, the only way that that water was getting into the house was for that house to get annexed in, and there has to be a
Mm.
special meeting to annex that property in so that they can get the assessment for bringing in city water.
Mhm.
So not everything is as it seems. So when these sellers put all the disclosures and everything, and they say, well, the city water is at the street. Okay, is your house really in the city limits? Because that can hold everything up if it's not.
Mhm.
So been there,
You're
done.
Yes, you're not wrong. So when you're looking at the disclosures, and you as the buyer's agent, it'll when you first look at the disclosures, it'll take a little bit for you to actually read them and know what they're talking about, right? This takes time, it takes practice, you got to keep going. Once you get into the point where you're comfortable with the disclosures, you'll be able to scan through the disclosures and there will be questions that you bring up to the listing agent or the seller, or you tell the buyer, hey, this might be a thing. It says it's not connected to city water, city sewer, but it says it's available. We need to check with the city. We need to check with the township. We need to figure out exactly what the situation is here. Because
Yep,
it could be that either they're not annexed into the city, so they're not eligible for city water, city sewer,
correct.
or that they had negotiated when city water, city sewer came through not to be hooked up, the seller had,
Mhm.
until a sale happened. And so then the new buyer would be required to hook up. That might be a negotiating thing that we need to figure out. So
Yep.
it is, I know a lot of agents who don't even look at the disclosures. They require their buyer to do that. I do not recommend that at all. You need to be looking at the disclosures because you are the professional. You're the one that has the knowledge, so that you can bring up these questions to make sure your buyer is getting into the right thing that they want.
Yeah, and the other thing I was going to mention, and we talked about it previously, was that there was another property that one of my buyers was interested in, where during certain times of the year the drain didn't work, and then I went over to the
Mm,
sewer district and pulled the drawing to find out that it was only 18 inches below grade, right underneath the brand new driveway that they installed. So it was going to cost a lot of money to tear out the driveway, sink down the drain to a below frost level, and
mhm,
then reinstall everything that they just dug up. So
mhm.
it can cost a lot of money.
It can. And our job as buyers agents is to make sure that our buyers are
Protected.
not go yeah, are protected. They are going to have bills after they buy the property, right? It is for whatever reason, it feels like a fact that the water heater goes out after closing, right? That a huge rainstorm comes through that has never happened before, and now you have water in the basement, and it happens after closing. You will get those phone calls from your buyer. Um, Unfortunately, part of that is part of home ownership,
Mhm.
right? Is that you are required to upkeep the property after you own it. If it's something that the seller didn't disclose, talk to your managing director. We can definitely walk you through how to handle that if it is something that they didn't disclose and that you can prove that the seller didn't disclose. We have had that happen a couple times, but there's that. Okay. But speaking of city water, city sewer,
Mhm.
um, this information talks about, is there city water? Yes or no? Is there city sewer? Yes or no? Or is there a subsurface sewage treatment system, also called an SSTS or a septic system? And is there a private well? Okay. And if for both of these, for the septic and the well, the seller has to fill out another disclosure for the septic and the well and a location map so that everybody knows where these things are. Okay. So if those aren't a part of your disclosures, you need to make sure your offer is contingent on your buyer receiving those, receiving, reviewing, approving those. Okay. If it's city water, city sewer, yes, yes. Does not, does not. This becomes really easy. And your purchase agreement is not contingent on testing the septic or the water. Okay. Now, the state is updating the wording here right now. The inspection of the well, how it's written makes it sound like they're inspecting whether or not the well works. And that's not what they're inspecting. They're inspecting the water quality and
Right.
what's in the water. So the state is updating that. You'll see that August 1st when the new forms drop. But just FYI, if you have a question. But the same holds true for the septic system, is that you're not testing if your buyer does want to have an inspection of the septic and the well. Now, this is different. This inspection is different than the home inspection that we talked about before. So if they do want to have inspection of the septic and the well, the septic guy is not testing to see whether or not the septic system works. They're testing to see whether it's compliant
Right.
with the county and state laws, which does not always mean that it works. So when you get those reports back from the septic company, from whoever's testing it, make sure you read the notes because septic inspectors they will put compliant because technically the property is compliant, but in the notes, they will put, this property's only rated or this septic system's only rated for a 3-bedroom. Seller has added 2 more bedrooms, and this is actually a 5-bedroom house. So
Mhm.
technically, per the rules, it doesn't fail. It's still compliant, but it's a too small of a system for this type of house, which matters when you have a retired couple living in a home and they're selling to a couple with 6 kids, right? That's when that piece matters. Same thing when you're talking to your buyers about septic inspections. If the county that you're in doesn't require a due on sale inspection, which means that if the property transfers, a septic inspection has to be done, whether it's done during the purchase agreement time or whether when the buyer can take it on after they own it, okay? Can be either or, but it triggers that inspection. So in counties that don't have that trigger, it's up to your buyer whether or not they want to have a septic inspection. If the septic works and it's been working forever, you don't always need to have one because it's not testing whether or not the system works, it's testing whether or not it's compliant. There are
And
a lot of properties that we've sold where the buyer chooses not to have a septic inspection because they know they're going to add bedrooms. They know that they're going to have to update the septic system anyway. And so they don't ask the seller to have the septic inspection because they're just going to use it as is. And that's okay as long as county doesn't have point of sale requirement.
and one of the questions you need to ask if you are listing houses, when was the last time you had your septic pumped?
Mm-hmm.
And if the answer is I've never had it pumped, you have an issue. And you need to talk to them right then and explain to them that they're probably going to have to update the septic system
Mm-hmm.
and escrow for it,
Yeah.
especially this part of the country where if it's in December or January, you're not putting in a septic system.
Mm-hmm. That's
So,
exactly. Yeah. Once that frost goes in, it's very hard for septic companies, one, to test the septic, number one, because they have to do drillings,
yep.
borings, and number two, to put it in because everything's frozen, right? So yep, so definitely a conversation you need to have with your sellers about their septic system. Has it been pumped? Do you have a compliance report? When was it put in? We still have properties that we're selling in our area that the septic was put in the 80s. And so it's a seepage tank. which are not compliant,
Right.
but it works,
Yeah.
you know? So and that's the conversation, which is why those net sheets are so important when you have those conversations with the seller. If you are fairly certain that the septic needs to be updated, put it on the net sheet so the
Mhm.
seller can see what their bottom line is, right?
Yeah.
Now, if the septic is non-compliant, you negotiate between the buyer and the seller. It's not a requirement that the seller updates it unless that's how you write the purchase agreement. But in the boilerplate of the language, that's not what it says. It says that it reopens negotiation if the septic doesn't pass, if the water test doesn't pass. Okay. And we'll talk about that more when we actually go over the addendum about the septic and well inspection contingencies. Okay. Then we get on to the home protection and warranty plans. This is just an advice that we've advised them that home warranty and home protection plans are available. We do have some home warranty contacts that we can put into place. Most of the time, you're going to say no home protection, home warranty plan is negotiated. What this is asking is either the buyer wants a home warranty plan to be paid by somebody, to be issued by a company at a cost not to exceed whatever cost that you guys negotiated here, right? We have seen this sometimes, most of the time, 99% of the time, there's no home protection or home warranty plan that we put in our purchase agreement. It can be a really good advertising tool for you guys because you as the agent can pay for the home protection plan for your buyer instead. Um, and that, happens in other part of the country, particularly in the cities. It is a nice closing gift, a nice thank you gift to your buyer for using you. But most of the time it's not negotiated in the purchase agreement. However, if you do want to do it, this is the place where you do it. Then we get on to the agency notice, okay? So this is who represents who. So if I'm with Coldwell Banker Clack and Dennis and I'm the seller's agent, I would click seller's agent. And let's say Amy Gordon here with Crown Realtors is representing the buyer. Now, just because both of these companies say Coldwell Banker does not mean it's dual agency.
Right.
Coldwell Banker is a franchise. Our franchise is Crown Realtors. There's another franchise called Coldwell Banker Realty. There's another franchise called Coldwell Banker at the Lakes. Just because it says Coldwell Banker does not mean it's dual agency. However, if you are selling a property that is listed by Coldwell Banker Crown Realtors, then both of you would become dual agents. And I don't know if you saw this form automatically, it doesn't allow you to check more than one in these areas, right? And so if you were dual agents and you were both with Crown Realtors, you would check the dual agent box. This is not where your client consents to dual agency. Your seller has to consent to dual agency in the listing contract. Your buyer has to consent to dual agency in the buyer's representation contract. And then I'm going to skip this piece for just a sec. And then if it's dual agency, you would click for 414. That dual agency does apply, and both the seller and the buyer have to sign. Okay. If it is not dual agency, we're a seller's agent, buyer's agent, then we would click does not apply, and we would skip the rest of this.
Right.
Now, Authentisign will automatically put signature blocks here. My recommendation is that you remove them if it's not dual agency to avoid confusion. Okay. Okay. Then the last piece is the facilitator, right? If you are a facilitator for a contract, you would click those ones. Now, we are having a training on facilitators and contracts and how you disclose all those things next week on Tuesday. And that's for the whole company. And we are seeing more and more facilitator deals
Mhm.
because sellers are finding their own buyers and they don't want to deal with the paperwork, so they bring it to us. So we're going to talk about all of that. Then We're going to talk about the wonderful compensation piece. So we've talked about compensation before as a buyer's agent and as a seller's agent, and that a buyer's agent can be paid with three different buckets, right? They can be paid from their buyer directly, or they can be paid from the listing brokerage, or they can be paid from the seller directly. Okay. Or they can be paid from all of those or just two of those, right? But those are the buckets on how the buyer's agent gets paid. When you're filling out your contracts, if the seller, I'm sorry, if the listing agent has not given you a cooperating broker compensation agreement, then you need to be asking your buyer if either they're paying your commission or if they want to ask the seller to pay your commission. This is where you put that in there. Okay. It says seller agrees to pay buyer's broker's compensation at closing of blank percent of the selling price or a base dollar amount, whichever is greater. This is in addition to any seller's contribution to buyer's closing costs. Remember, that was farther up in the purchase agreement that we could ask the seller to pay for some of our buyer's closing costs. This amount is in addition to also the listing broker's offer of cooperating compensation, which is why I said you can get it from all three buckets or just two buckets, to be able to fulfill your buyer's obligation to you as their agent for that compensation. Okay, so that's where you put it. If you don't have that cooperating broker agreement in hand and signed from the listing agent, put it in here. Most agents, I shouldn't say most, a lot of agents are getting the terminology wrong when they're having conversation with buyer's agents. When we call and say, "Are you offering cooperating broker compensation?" They say, "Yep, the seller is, just put it in the purchase agreement." That's not cooperating broker compensation. That's a seller concession to the buyer broker compensation, right? However, it's not worth the time to argue. If you're getting paid, you're getting paid, right? It's their broker's job to make sure they're using the right terminology. And some people just trip up. They're just really busy and they're like, yeah, 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 we are. Put it in the purchase agreement, right? That's fine too. But just know that if you put nothing in here and your buyer can't pay you because they don't have money, you're going to have a problem or you're going to be doing the job for free, right? Okay. So we talked about dual agency. Um, did anybody have any questions about any of the other stuff? No? Okay. Then we get into wonderful legalese here, but we're almost there. We're almost done. So, closing costs. This is just a notice saying that the buyer and seller will have closing costs that are outside of what's in this purchase agreement. That can be mortgage payoff, that can be different taxes, different liens. For the buyer, it's usually their loan requirements. State deed tax for the seller. This is just a notice. Hey, just so you know, you will have closing costs again, which is why the net sheet is important and helpful. This then talks about the settlement statement, like Terry had talked about. The settlement statement is the final numbers. It is not the estimated net sheet that we do. It is the final numbers from the closing company. Okay. And this piece authorizes the title company to send us the settlement statement so that we can look it over, make sure everything's in there. We just ran into this morning in Park Rapids. In the purchase agreement, the seller offered the buyer a $500, I don't want to say kickback because that's not right, but they offered the buyer $500 at closing because the dishwasher didn't work and the seller didn't want to deal with it. They had enough on their plate with other fixes. They're like, "Can we just give you $500 at closing?" Buyer was fine with it. But when we got the HUD statement, the settlement statement, that amount was not accounted for on the settlement statement. It's little things like that that you got to catch, right? If you're selling a property in a common interest community or an HOA, you want to make sure that those amounts are in that settlement statement and that everybody's on the same page. Okay. Then it talks about FIRPTA. FIRPTA, Foreign Investment in Real Property Tax Act. Essentially, what this is saying is if the seller is a foreign person, they are still required to pay taxes based on their gain of the property. However, because the government can't impose taxes on a foreign citizen, the burden gets shifted to the buyer of the property. And what this says is that if the buyer of the property who buys the foreign seller's property doesn't make sure the taxes are withheld at closing, that the buyer's responsible for those taxes. We usually don't have to deal with this. That is the very basic overview of what this says. The only thing that you need to be calling your managing director about is if, hang on this page here, FIRPTA says that the seller says that they are a foreign person. Then as a buyer's agent, you know you need to pick up the phone, call your closing company, call your managing director and say, what do I need to do to protect my buyer here? So they're not on the hook for the seller's taxes.
Mhm.
Okay. So that's what that says. Also, it says seek advice, seek appropriate legal and tax advice. So always tell your buyer to go talk to a tax accountant, go talk to an attorney, before this becomes a full agreement, before we all agree. Go talk to them to make sure that we're doing this correctly. Okay. Then it goes on to say, fully executed purchase agreement. What does that mean? It means that this purchase agreement to be binding, all the addenda and the purchase agreement must be fully executed, meaning signed and dated, and a copy must be delivered. Now, that copy can be delivered to either the agent or the client directly. Okay. But once that happens, then final acceptance happens. So it's not always final acceptance date, which we'll talk about a little later, is not always the very last date of what everybody's signed. Sometimes it's the next day
Mhm.
because buyers signed on Thursday, but they didn't send the signed copy to the listing agent till Friday. So sometimes it's Friday. That's why Christine's so crazy about putting the final acceptance date on all of our stuff because the final acceptance date also triggers all of our inspections. All of our dates that we're following is triggered by that final acceptance date. Okay. Then it goes on to say, like all of our contracts, we can use electronic signatures and they are valid and binding. If you haven't taken the electronic signatures CE course that the CE shop has, it's actually really interesting on how these became commonplace and how they became binding. Just fun factoid stuff. Then it talks about that this entire agreement is binding. What this says is this purchase agreement and all addenda and amendments signed by the parties shall constitute the entire agreement between buyer and seller. Any other written or oral communication between buyer and seller, including but not limited to emails, text messages, electronic communication, are not part of this purchase agreement. This purchase agreement can be modified or canceled only in writing, signed by seller and buyer, or by operation of law, by a court order. Okay. All monetary sums are deemed to be United States currency for purchases of this purchase agreement. This is the piece where I say put it in writing. That's great that your buyer and seller are talking to each other and the buyer wants, grandma's old bench that's on the thing. Fine. I don't care. Put it in writing. If it's not in writing, it doesn't exist. Okay. And this is the piece that people miss. Well, I have a text message. Doesn't matter. It's not binding. There's no signatures. Doesn't matter. You have to put it in writing. Okay. This talks about the warranties specified in this purchase agreement shall survive the delivery of the deed or contract of deed. I Any warranties after the closing that were made will survive. That's what this says. I have not seen this come into play in the 13 years that I've been licensed so far. Okay. Because it's usually sellers aren't giving a warranty. besides the warranty deed, right? So just FYI. This talks about the date of this purchase agreement. So on all of your additional addenda and amendments, it will reference date of this purchase agreement. And this talks about that this is the date defined on line 1, like we talked about before. So, and then when you fill out line 1, it will fill out on the top of every single page of the purchase agreement. That is the date, that is the reference date that you're referencing to make sure all the documents are going with the right purchase agreement. Then this is the other category, and you can put whatever you want in here as long as it's legal and ethical. Okay. What I wanted to show you though was that we have clauses. So if you click into this, it'll have this add clause button. So because there are weird things that happen that you need to write in the purchase agreement, like we don't have disclosures. We're writing this as a buyer's agent. We don't have disclosures. We need it to be contingent on getting those disclosures. Instead of you having to think through how to write that amendment, how to write that contingency to make sure it's binding, that something happens with the earnest money, that you're not just saying that once your buyer receives the disclosures, we're good to go, right? We've put together as a company a whole bunch of clauses that you can use. And so some of them are inspection authorization report. Some of them are home inspection contingency release. Some of them are about seller pays. Um, let's see, what else do we got? We have escalation clauses that are in here. Okay. We have on market contingencies, seller to provide the abstract, all of those things. So if there is a clause that you need, it's probably in here somewhere. And like I said, how to get to that is you click in to the other category, you click add clause, and you go to office clauses. And there'll be a whole bunch of stuff in here. Okay. So this talks about septic compliance, the delay for weather contingency, the undersized, that the septic system is undersized. Okay. So take a minute to go through all of those clauses. Some of the clauses are very long, and you'll have to do it on an addendum to purchase agreement so you have more space. Okay, don't try to fit everything in there. You can have as many addendums as you want that are part of the purchase agreement. Then we talk about addenda. What you're doing here is when you're clicking these, when you're checking these boxes, is you're making sure that everybody's aware that even if I forgot to sign or to send the addendum to purchase agreement disclosure of lead-based paint, even if I forgot to send it, it is a part of this purchase agreement. Okay. Same thing for as is or a buyer move-in agreement. These need to be checked when you're putting them together. And so sometimes what happens is as you're writing this offer with your buyers, you start having a conversation and you're like, "Oh, I have to do lead-based paint." And you have to go back into the purchase agreement to check this box saying that the addendum to purchase agreement lead-based paint is a part of this agreement. Okay? Same thing with this septic and well contingency. We see this one forgotten a lot. Just because it's referenced at the beginning of the purchase agreement doesn't mean you don't have to check that those 2 pages of the septic and well contingency are a part of this agreement. Okay. Same thing with the sale of the buyer's home. Now, the one thing that we don't usually check is the personal property agreement. Because if you check addendum to purchase agreement here with the intention of adding the personal property agreement, or you check the other and you put personal property agreement, the bank is going to ask for that agreement. And if that agreement is of significance, right? So you're buying the property for 450,000. The seller's also including a tractor. with the property. The bank does not like to loan on personal property with a mortgage, with a 30-year loan, right? Those loans need to be shorter. And so you might have an issue with your buyer, particularly FHA rural development, if there's a lot of personal property with this personal property agreement, or it's a lot of value, and the value is being seen in the purchase price of the property. Here's my recommendation. The normal things that you're going to do with personal property agreements is anything that's not attached, any of the appliances, fridge, washer, dryer, dishwasher, right? All of those. When you do those, that's fine. Use our personal property agreement, but don't check anything here. Okay. Now, your other option is to use our personal property agreement and roll the dice, right? Check that the personal property is going to be included in here. And even though our addendum says that this personal property is going to be transferred at $0 or at $1 for due good and valuable consideration, roll the dice and see what the bank says. Okay. How I like to do this is having the personal property not be a part of the purchase agreement at all. It is a separate agreement between the buyer and seller, and the personal property agreement is contingent on this closing. That way, the appraiser can make value without having to appraise personal property. Bank doesn't have to do two different loans, one for the personal property, one for the mortgage. Okay. That's what my recommendation is, particularly if it's a lot of personal property. Come to an agreement on the purchase agreement, on the price that they're willing to pay for the home, and either do the personal property in conjunction or after you come to an agreement for the purchase of the home. It's a lot of ways to skin a cat with personal property. Biggest thing is you need to be in contact with your lender is I think the biggest piece. If it's a cash sale, it's not going to matter. Conventional, as long as it's not too much of a value, it's not going to matter. Okay. So don't forget to click those addenda. We'll do other trainings on the big ones in these addenda. Okay. Then you finally get to the last page of the purchase agreement. Yay! What this is saying, this is split into two places. So it's split right down the middle. This side to the right is your buyer side. This side to the left is your seller side. Okay. So sometimes buyer's agent will go ahead and fill this out that the seller is not a foreign person. That's fine. They don't need to. As a listing agent, it's your job to fill out this seller's side. So if your seller is going to send a counter offer back to the buyer, seller signs all of this purchase agreement. We check this box saying that there is a counter offer and that this agreement isn't done yet until this counteroffer is signed by all parties. Okay. Or if there's not a counteroffer, you would check the FERPTA box, have your seller sign, and then send it back to the buyer for final acceptance. On the buyer side, what the buyer is saying is, I agree to purchase the property for the price and on the terms and the conditions set forth above. I have reviewed all pages. That's what the buyer's signing. Okay. Then it goes, so this is the other piece. I agree to sell the property. This is for the seller for the price and on the terms and conditions set above. This is why it's two separate pieces, right? On either side. Like you don't continue to read it. It's two columns. I wish they would put a line like right here. That'd be great. Your people will sign, they'll print their name. The biggest thing about printing their name is to make sure that the title company has the correct spelling of the correct names. That's why we print the name here. Okay. Then it goes on to talk about the final acceptance date. Now, if you're doing a counter offer, the final acceptance date should be on the counter offer. There's another line that looks just like this, that's where you'll put the final acceptance date. Or if you're not doing a counter offer, the final acceptance date will go right in here. Remember, it's not just when the last person signs, it's when everyone gets a copy of the fully signed agreement. Then it goes on to give a notice to the seller saying and the buyer saying that this is legally binding, and if they need legal or tax advice, they should go find those professionals because we are not lawyers and we are not tax people, right?
So, quick question.
Yep.
Um, how do you fill in the final acceptance date if you don't know when they're gonna receive it?
So that becomes a conversation between you and the other agent. So like if I'm on the buyer's side,
Mhm.
and we send an offer and they just send it back to me with the seller's signatures with no counter offer, I know that I can fill in that final acceptance date because I'm receiving it as the buyer's agent and it's fully signed. That
Right,
triggers final acceptance.
right.
If, however, I send it to them, like they send me a counter, I have my buyer sign the counter, they're all good to go, and I
Okay.
send it to them, I'm waiting for the seller's signature, right?
Mhm. Yeah.
And so what it becomes is I used to just send an email to the other agent. Hey, so happy we put a deal together. I'm going to put the final acceptance date as this date. Are you in agreement? Or if you're not in agreement, please let me know.
So that's when you've received it, but
Yes.
what about your client?
So it's you because you are representing your client.
Okay, okay. Good thing.
Yep.
Clarified
That's
that.
the final acceptance
Gotcha.
date. So it's
Okay.
really agent to agent.
Okay.
Yep.
Gotcha. All right. Makes
hmm
sense.
Now, it is on you as the agent to make sure that your people get copies. Just because you receive it doesn't mean your job's done yet.
Right.
Right? Okay. You need to make sure they get all copies, always, period, no matter what. Okay. Then it goes into this little box. This box talks about arbitration. Arbitration can be used if there's a dispute of anything under $15,000 between the seller, the buyer, or the agents. Okay. If everyone signs arbitration, which is a different form, they give up their right to go to court and they can only go to arbitration. Arbitration is usually a panel of 3 or 4 judges. They're professionals in whatever issue you're bringing to them. So sometimes if you're coming to them with a roof issue, um, it'll be a bunch of roofers, right? Who own roofing. That's going to be your arbitration panel. And then you will bring all the facts, they will make the decision, and that decision's binding. That's what arbitration is in a nutshell. Okay. Anything over $15,000, all parties still have the right to go to court. Every every agent that I've talked to is kind of split about whether or not you tell your buyers or sellers to sign arbitration or not. I always felt that if you don't sign arbitration, if you don't agree to the arbitration, you have 2 options. You can either go to court or you can go to arbitration. But if you sign arbitration, you give up your right to go to court for anything under $15,000. I never understand why anyone should give up their right to go to court. Is arbitration sometimes the better option? Yeah, of course, it's much cheaper than hiring a lawyer and going to court. However, if they have the option to do either, if they don't sign, in my opinion, you should let them have the option. Some agents feel that if the property is under a certain value and your commissions in particular can be a part of that arbitration disagreement, that if your commission is less than a certain amount, then you should be having everybody sign the arbitration agreement so that you don't have to go to court. You can just go to arbitration because it's cheaper to do that, to go to arbitration if the other party doesn't agree. And while I understand the thought process, again, I don't believe in giving up your right to go to court. So that's my feeling. You can have your feeling. Neither one is wrong. It just depends. But this piece is not agreeing or disagreeing to arbitration. This piece is just acknowledging that the client has received and had the opportunity to review the arbitration disclosure. Okay. Goes on to say this is an optional voluntary agreement separate from this purchase agreement. Regardless of whether or not everybody signs arbitration, this purchase agreement is still binding. This is just an acknowledgement that you as the agent have talked to them about it and they understand it. That's it. Okay. And that's the purchase agreement. Then we talk about wire fraud again. So this is not technically a part of the purchase agreement. This document is not technically a part of the purchase agreement. It is just a notice to everyone in the transaction. Wire fraud is an issue. They hack into email accounts. They have them wire money. We've caught just this year, we've caught 3 of them trying to get our sellers or our buyers to wire their funds to these scammers. And the email accounts are very sophisticated. They look like they're real. So tell your clients every bit. I know we see this form a lot in all of our forms. It is incredibly important to tell them, hey, don't forget, if you get an email about wiring funds anywhere, or giving your bank account information to anyone, call me first. Call me on the number that I gave you. Call me first. Okay. Perfect. These signature pieces here are for the seller and the buyer, just so that we've done our job to say we've talked about this. That's all. Just a protection mechanism for us. Okay. That is the end of the purchase agreement, guys. There's so much in it.
Yeah.
Yes. Did anybody have any questions as I was going through that? Was your mind blown? Are you pretty okay? Will it make more sense once you start filling one out for yourself and actually see how this works in practice? Absolutely. Yes. Um, Perfect. Okay. That's all I've got for you guys today. Go enjoy your Friday. Have a great weekend, and we will see you, well, on Tuesday for the facilitator contract, 9 a.m. You'll see an email from me on Monday. Oh, and the huddle. So we started a huddle at 8:40 on every Monday morning. You should have gotten an invitation for it. And it's going to be quick and easy, right? About 10-15 minutes every Monday morning at 8:40. What's going on? What celebrations do you have? What problems do you need help with? Right? It's just going to be quick and dirty for all of our agents. Okay?
Perfect.
All right. Cool. If you need me, call me. You have my number. Otherwise, we'll talk to you guys later.
All right.
All right. Bye.